We have a webinar coming up. Joining us today, though, to discuss today's issues of data use and access bill, we've got our regulatory expert, Naomi Grossman. Hi, Naomi. Good to have you with us today.
Hi, Nick. Thanks for having me. It's great to be here.
And we also have Harry Lindsay from our business development team who works with companies large and small, helping them find the right compliance solution. Great to have you with us as well today, Harry.
Hi, Nick. Lots to talk about today. I'm really excited to be here.
Absolutely. So we will be talking about the key provisions of the Data Use and Access Bill, discussing its potential impact on business, and talking about practical steps to help your organization stay compliant and ahead of those regulatory changes. But whether you're dealing with AI-driven decisions or managing legitimate interests or navigating new data sharing initiatives, we would like to provide insights on all aspects of compliance, which is why we've just published this fantastic new guide to buying compliance tech. So if you're thinking about making any purchases of compliance-related technology in the next year, make sure you get a free copy of Buying or Buyer's Guide to Compliance Tech, which lists all of the best buys for different compliance technologies, for different aspects of compliance. And that link is coming up in the chat now. And we also have some different ways VentureWorks can help with your own data protection compliance. So if you're looking for any software to help track everything related to data protection, you can write OmniTrack into the chat box if you'd like to see more about that software. Or if you're interested in courses which you can roll out across your organization on data protection, please write data protection courses into the chat box and we'll be in touch with you to sort that out. And as we said before, we'd love to hear from you during this webinar. What are your questions on the Data Use and Access Bill? Do let us know in the chat and we'll get through some of those in the next hour. Now, we are covering a lot today, but there will be a recording coming after, and the webinar is obviously recorded and available online afterwards. We also have a guide to the top compliance trends and challenges in AI, GDPR, and data protection. A link to that document is coming up on the screen. If you want something to take away after this webinar, have a read through and get a sense of some of the issues that we're all dealing with in this data protection world. So, with all that out the way and with those links for you there in the chat, let's get into the details. Let's start at the beginning, Naomi. What is currently the UK's data protection rules?
Great question, because data protection legislation has been around for a very long time. There was the Data Protection Act 1984 in the UK. Then the EU passed its Data Protection Directive 1995, which the UK gave effect to with the Data Protection Act 1998. Obviously, with the digital age in the last few decades, these laws really needed an update. The EU worked for a number of years on the General Data Protection Regulation. That's the GDPR that we all know and love so much. And this was adopted by the EU in 2016 and came into effect May 2018 across every country in the EU, of which the UK was a member at the time. At the same time, the UK updated its domestic legislation with the Data Protection Act 2018, which complements the EU's GDPR and applies the data protection standards set out in GDPR into UK law.
Obviously, since then, we've had Brexit and the UK has left the EU, but it retained GDPR.
That's exactly right. UK GDPR copied and pasted, essentially, EU GDPR into British law to make sure GDPR would remain the law even after Brexit. The vast majority of things in UK GDPR stayed the same. The rights, obligations, the key principles. The main change was around personal data transfers between the UK and EEA. But because the EU said the UK's data protection rules are quote unquote adequate, there was no need for additional restrictions on data transfers. The UK retained GDPR, which continues to be used alongside the Data Protection Act 2018 to define the UK's data protection standards.
Thank you very, very much for taking us through that, Naomi. So that's the state of the play at the moment. We have UK GDPR, which remains essentially the same as it was back in 2018. But that's what the UK is looking to change that. And it feels like we've been waiting for quite a long time for these changes, Harry. What's been going on in Westminster?
Thanks, Nick. That's absolutely right. So the UK has been talking about changing GDPR for a while now. The last Conservative government introduced legislation called the Data Protection and Digital Information Bill, which we might remember as the DPDI. This laid out quite a significant series of changes to UK data protection rules alongside quite radical changes to the Information Commissioner's Office. The DPDI got very, very close to becoming law, but the UK's general election last summer meant that all legislation that hadn't yet passed was dropped when Parliament dissolved, and this legislation didn't quite have enough parliamentary time to make it through to the end. So it was dropped, and the Labour government have started from the beginning with their Data Use and Access Bill, which is currently going through Parliament.
Very, very helpful summary. Thank you very much. Now, something we were quite worried about with the old DPDI bill from the Conservative government was that it could potentially jeopardise this adequacy decision that the UK has from the EU. Is that a risk this time with the new Data Use and Access Bill?
Hopefully not, but the short answer is we really don't know at this stage. With the government's DPDI bill, there were some voices in the European Parliament which said the changes could affect the UK's adequacy decision. But since that legislation never got passed, we don't know what would have happened. There haven't been the same level of worry about it, Labour's data protection changes, and we haven't heard those same concerns from the EU either. But of course, it is still definitely a risk. Ultimately, the EU's adequacy rules are a political decision. So it's up to the EU Commission what countries are considered adequate. So it really just comes down to negotiations between governments. My feeling is that the UK's adequacy decision will not be affected by this legislation.
That would certainly be a relief if it's not affected by that. So we know that the Data Use and Access Bill will be making a number of changes to data protection law in the UK. We'd like to ask you, the audience now, are you planning to roll out new training to your staff once these changes are enacted? So the question has popped up on the screen. Are you planning to roll out new training to your staff once the changes are enacted? Yes, we'll quickly be retraining all of our staff, or you can select yes, but within our existing training schedule. We'll assess the situation once DUAB is in force. No plans to retrain or not sure. So we'll give everyone another moment to answer that question up on the screen. And the options are yes, we will quickly be retraining all of our staff. Yes, but within our existing training schedule. We'll assess the situation once DUAB is in force. No plans to retrain or not sure. So we'll give everyone another moment to give their thoughts on that poll question. Interesting to see what the audience thinks. So 10% said yes, so we'll be quickly retraining all of our staff. 18%, but within the existing training schedule. 45% are going to assess the situation once the UAB is in force. 7% no plans to retrain, and 21% not sure. Very interesting results there. I think a relatively fair reflection of where we're all feeling with the possibility of the changes that are coming through, and wanting to really wait and see what actually will be the case, because things can change quite quickly. Just a reminder, we'd love to hear from you during this webinar, particularly if you've got plans to retrain. What are you waiting for to see? What are your concerns around the UAB compliance? Do write to us as we go through. So Naomi, how far along is the Data Use and Access Bill in the parliamentary process?
So it's quite far along, actually, and almost half the people on the webinar are in the wait and see, but it's coming along. The legislation started its journey through Parliament in the House of Lords. This starting point does have its advantages for the government. It's let them move past the more intense scrutiny of the initial stages, while peers and NGOs are still getting up to speed on the details. Since the bill carries over many ideas from the previous government's legislation, we didn't think it was going to face that much opposition, but it actually was subject to some quite fierce debate in the Lords in the last few weeks.
And what was that about? What are these points of contention?
So there was a really strident debate among the Lords over issues of AI, not surprisingly, copyright and intellectual property. At the end of January, the government actually suffered a rare defeat in the House of Lords when peers voted 145 to 126 in favor of adopting a series of amendments designed to provide greater protections for copyright owners against AI scraping. These amendments were tabled by crossbench peer Baroness Kidron, and she said her measures would record when, where, and how intellectual property is taken, and crucially, allow creators to understand what has been taken so they can seek redress.
And we're seeing a lot of those issues come up in the press at the moment with all those AI discussions. And Harry, how does this kind of debate around AI and copyright come to gather so much support?
So the vote on these amendments is really about the struggle between the creative industries and big tech firms over the use of copyrighted material to train AI models. Baroness Kidron, backed by the Creative Rights in AI Coalition, which includes major organizations like the Publishers Association, UK Music, and the Motion Picture Association, has argued the government's current approach effectively allows AI firms to harvest creative works without compensation or transparency. Her amendments were also backed by Sir Elton John and Paul McCartney.
So the government lost that particular vote in the Lords on that aspect of the bill, but where is the legislation now, and what do we think will happen next?
So currently the legislation is sitting at the committee stage in the House of Commons, having passed the Lords with those amendments. You can see from the image on the screen, it's passed all of the Lords stages and now is in the Commons. It's really up to the government to decide whether they accept those amendments or send the bill back to the Lords again and try to overturn them. That would likely slow down the legislation quite a bit, since the Lords have the power to delay bills. The government could offer a compromise on the issue of AI and copyright, or just agrees to the amendments completely. We'll have to wait and see what happens and see what they decide to do. That's really been the most controversial element of the data use and access bill. Most of the rest of it, the parts that change how data protection rules work for most businesses, seem to have relatively consistent support.
So given that we know actually quite a lot of what will quite likely be in the final law once it passed, let's actually ask the audience again now about your preparations for the DUAB once it comes into force. So thinking again about the training aspects of making sure your staff are compliant, how will you ensure your data protection training is DUAB compliant? So the options up on the screen there are that our content provider automatically updates our training, we'll update the training ourselves, we'll need to purchase new DUAB compliant training, don't plan to do any DUAB training, or not sure. So just thinking about how you'll make sure that future data protection training is compliant with DUAB. The options there on the screen are that your content provider automatically updates your training. We'll update the training ourselves. We'll need to purchase new DUAB compliant training. Don't plan to do any DUAB training, or not sure. So give everyone just a moment to answer that question, and we'll see what our audience is planning to do around making sure training remains compliant. So 23% says our content provider automatically updates training. 31% will update the training ourselves. 6% will need to purchase new DUAB compliant training. 3% don't plan to do any training, and 38% not sure. And I think that's very, very fair reflection of where we stand at the moment. We're still waiting for the legislation to come into force. And just a reminder also that any VinciWorks client, if you are already a client of VinciWorks and you currently license our data protection suite, you will have your UK data protection courses automatically updated once the DUAB comes into force. So let's now take a look at the data use and access bill in some more granular detail now. Naomi, what actually is the legislation trying to do here?
So we can really start by looking at what the DUAB carries over from the last government's data protection and digital information bill, because it's actually quite similar. It establishes a new lawful basis for processing known as recognized legitimate interests, which lets public bodies request data from other organizations, including private companies, to support their work. There will be limited rights for individuals to object to this data sharing, especially if processing is justified as a legitimate interest. Processing under legitimate interest will include processing for the purposes of direct marketing, maintaining the security of network and information systems, and intergroup transmission for administration purposes. Despite these being allowed, such processing activities will still be subject to the balancing test and the data subject's right to object.
And these changes to processing activities, I think it'll be quite significant for many businesses, won't they?
Oh, absolutely. It's totally right. Because DUAB clarifies that further data processing is allowed if it aligns with the original purpose of collecting the data. So the government will have the authority to decide what qualifies as compatible processing. DUAB also maintains a lawful basis, allowing U.S. law enforcement agencies to access UK telecommunications data for serious crimes investigations. So that might help businesses comply with information requests from law enforcement authorities.
Mhm.
However, in opposition to GDPR, DUAB allows the extensive and really relatively unfettered use of AI or other automated processes for decisions on really very personal data. This excludes special category data, but restrictions on automated decision making will continue to apply to special category data. This is different from the current position under UK GDPR, where automated decision making is restricted on all personal data that has a legal or other significant event on the data subject. That could include applications for a loan or even for employment purposes.
So what do we think these I guess, relaxations on the rules around AI and automated decision making will mean for everyday businesses?
So this change under DUAB could enable profiling and automated evaluations in scenarios like employment screening. However, organizations using AI for decision making must still put safeguards in place, allowing individuals to challenge or appeal decisions made solely by machines. More restrictive measures remain for cases where automated decisions significantly impact individuals, especially if they rely on sensitive data such as health, political views, or biometric information. For such sensitive cases, automated decisions will require explicit consent and be legally mandated or meet criteria for a substantial public interest. While the government have not yet announced their own AI bill, this suggests the UK's approach to AI regulation will not be as strict as the EU's. That's the messages we've had coming from this government in recent weeks anyway. Scientific research receives a substantial boost under DUAB, with commercial research now qualifying under the, quote, scientific research, quote, category. This reclassification means that data subjects' consent for research use can continue as projects evolve, provided the research meets ethical standards. By expanding research definitions and relaxing restrictions, DUAB seeks to foster innovation while aligning with public expectations for ethical data use.
So with all these kind of changes to how companies are using and can use data coming along the way, what else do we need to know about the changes in the bill? Because I think there's differences around subject access requests as well, which I believe are really important for us to know about to handle these subject access requests correctly.
Yeah, you're absolutely spot on. So DUAB outlines clearer timelines for handling data subject requests, such as limiting the scope of searches for requested data to those who are, quote, responsible and proportionate, unquote. Data controllers, meaning the organizations who actually hold people's data, will be allowed to stop the clock as such on a subject access request response time if they were unable to respond to a request without receiving further information or clarification from the person making the request. The exemption for disproportionate effort or impossibility has been revised regarding the requirement to provide information to data subjects when their data was not collected directly from them. The revision clarifies that the exemption applies to all types of processing and includes a non-exhaustive definition. For example, if an organization processes publicly available historical records for research purposes, it may be exempt from directly informing each individual if doing so would be unreasonably difficult or impossible. There's also a requirement for data subjects to first file complaints directly with the data controller before escalating to the ICO, aiming to streamline resolution at a company level. So the bill relaxes restrictions on marketing by allowing third parties to use an opt-out approach for contacting individuals rather than requiring explicit consent.
Thank you for that. Very, very interesting. Good details to know. And if you'd like to know more about dealing with subject access requests, then you can download our best practice guide to subject access requests coming up in the chat now. So there's so much to understand and track within our business on this. We've had a couple of questions on the subject that have come on the chat, and I just want to address a couple of those briefly. So one question was whether the amendments that affect the companies who don't operate in the UK but provide services to UK citizens. So if your company is based outside of the UK but you do work in the UK or offer anything for process UK citizens' data, this will apply to you, and it is worth doing a new review or auditing your policies to make sure you're in compliance with the new legislation when it does come into force. Another question we've had then is, does the legitimate interest application only apply to public bodies? As far as we know, it's for everybody. So it's not just for public bodies, but companies and organizations will be able to make use of the new legitimate interest rules as well. So with so much to understand, to track within our own businesses and all these changes, we want to ask the audience just how you're planning to keep up with all these changes and differences with our data protection rules within our organizations. So the question up on the screen there is, do you have any kind of automated system for tracking your GDPR data protection obligations and breaches? So the options there are, yes, we do. Yes, but we're looking for a better one. No, but we're looking to get one. No plans to automate GDPR compliance, or not sure. So thinking about how you're actually managing your GDPR and data protection obligations and breaches, notifications and data registers, all that sort of thing. How are you doing that within your own organization? Yes, we do have an automated system. Yes, we're looking for a better one. No, we were looking to get one. No plans to automate GDPR compliance, or not sure. So we're going to give everyone a little moment to answer the question. We'll have a look at what the audience thinks. So 12% do have an automated system for tracking their GDPR and data protection obligations and breaches. 2% are looking for a better one. 8% looking to get one. 52% no plans to automate GDPR compliance. 26% not sure. Interesting set of results there. And if you do want to know more about VinciWorks' own automated GDPR and data protection compliance solution, you can write the word OmniTrack into the chat box and we'll be in touch. Or if we can help with training, please do write the word courses into the chat as well. And we also have a new guide to managing GDPR and data protection, no matter where in the world you're located. The link to that one is coming up in the chat now. If you have any issues accessing the link, let us know and we'll get you a different way to download that guide. So let's get back into those details of the data use and access bill. And there's some new provisions in the legislation that we need to pay attention to. And one new term we're going to have to learn is neurodata. What is neurodata, Naomi, and why do we have to worry about that?
Right. It's a great new term, and our vocabulary keeps increasing as the digital age goes on. So this is a new term that the legislation introduces that's essentially a new category of sensitive data. And it's called neurodata, which for obvious reasons, but it includes information like what's collected from devices like smartwatches. It refers to data generated or collected from devices or technologies that monitor, interpret, or interact with the human brain or the nervous system. I know this all sounds a little bit frightening, but I guess if you have a smartwatch, you can understand. It. It keeps track of your heart rate. It keeps track of your blood pressure. Now, this is often considered first-order data that can be used to create second-order data, which is important. It's a form of sensitive or special category data due to its obvious potential to reveal intimate details about an individual's cognitive state, their health, their behaviors. The introduction of neurodata as a special category under privacy laws was actually a very smart move from the ICO. And it really highlights the need for heightened protections and ethical considerations when processing this kind of information.
So on the one hand, we're getting increased protections for things like neurodata, but I know another big part of the data use and access bill is the reform to the e-privacy regime in the UK. Remind us what is e-privacy and how it applies to us.
Right. No, it's a great question. So the UK's e-privacy regime regulates various aspects of digital privacy, including direct marketing and the use of cookies and other tracking technologies. The changes proposed aim to modernize these rules, which actually stems from the EU's e-privacy directive way back in 2002. So it's really at the beginning, almost the beginning of this new age. It was supposed to be updated alongside GDPR, but the EU was never able to really reach an agreement, so it never got updated. But now the UK is updating e-privacy rules as part of DUAB. One significant change is the expansion of rules governing the storage of and access to information on user devices. So the revised regulations will explicitly cover the collection and monitoring of data automatically emitted from a user's device, such as IP addresses and device identifiers. They will also apply in cases where storage access is initiated remotely, like the use of server-side tracking. This update also introduced new exemptions for certain cookies and tracking technologies. This means that some will no longer require explicit user content as long as users are provided with clear information and the right to object. So exemptions may include analytics cookies that help website owners measure traffic and performance, preference cookies that store user settings such as language preferences or dark mode selection, and security-related cookies that detect fraud or enhance network security.
And what other changes are happening around cookies? I know there's quite a lot happening in that area.
Yeah, so the government will also be given the allows for adjustments in response to new technological developments or emerging ensuring that the reform involves significantly increased penalties for breaches related to direct marketing and the use of cookies. Currently, fines are capped at £100,000, but under the new rules, violations could lead to fines equivalent to those under UK GDPR, up to the greater, either £17.5 million or 4% of a company's total annual worldwide turnover. This increase is intended to stir practices and intrusive marketing tactics, such as nuisance calls and unsolicited advertising.
Thank you for that. And apologies that Naomi was sounding a bit choppy there. It does sound okay in the recording. So any parts that you might have missed will sound fine in the recording, but we will do our best to sort that internet out right now, and we'll make sure that she sounds better in a moment. But let's now look at some of the changes being proposed to the Information Commissioner's Office. Harry, the government is looking at some quite radical reform of the UK's Information Commissioner.
Yeah, they certainly are. So although the changes to the ICO are not quite as significant as the last version of the legislation from the previous government, they are still quite significant. So the functions currently handled by the Information Commissioner's Office will transition to a corporate entity called the Information Commission. Now, this change is intended to streamline operations, while new rules requiring the data subjects to first lodge their complaint with the data controller will reduce complaints reaching the ICO by requiring that data controllers address complaints first. The new Information Commission will inherit many of the ICO's responsibilities, but it will also have an expanded mandate. For instance, it will be legally required to consider the promotion of innovation and competition when making decisions, ensuring that the regulatory environment not only protects individuals' data rights, but also supports economic growth. This means that when evaluating potential breaches or compliance issues, the Commission must balance the need for strict data protection with the benefits that technological advancements and competitive practice can bring to the market.
We assume also will still have powers of enforcement and investigations for data protection incidents.
Yeah, that's absolutely right. And actually, these powers will be enhanced. So the new Information Commission will have the authority to require organizations to produce detailed reports or even compel individuals to attend interviews as part of its investigations. For example, if a business is suspected of not adequately protecting personal data or of failing to meet its data subject access obligations, the Commission could order the company to compile a comprehensive report outlining its data processing activities or demand that key personnel explain the internal processes used to actually safeguard customer data. Another significant change is related to the timing of enforcement actions. So currently, the ICO is required to issue a penalty notice within 6 months of declaring its intent to fine an organization. The reforms will allow the Information Commission to extend this period beyond 6 months when necessary, as long as the final penalty notice is issued as soon as is reasonable practicable. This flexibility is particularly important for complex cases. For instance, investigations involving multinational companies with intricate data flows may require more time to fully assess all processing activities. In those cases, the extended timeframe will enable the Commission to conduct a thorough and balanced investigation before imposing any sanctions.
And what about then the fees that we have to pay to register with the ICO or this new Information Commission? What's happening there?
So those fees are actually going up on all tiers. So for tier 1 micro organizations, the fee is now £52 up from £40. So tier 2, we've got small and medium organizations, which has increased from £70 to £78 from the previous £60. And then we've got tier 3, which is large organizations and now stands at £3,763 compared to the earlier £2,900. Now, it's important to remember that all organizations which process data in the UK should be registered and can be fined if they fail to do so.
Thank you for that. Very important for us to know and to remember, and making sure that we take into account that fee structure is changing. Now, with so much we've been looking at around the world of AI, we want to ask another poll question about that specifically. Have you implemented any procedures, training, or other preventative measures to protect against compliance breaches by AI? Yes, we have a range of preventative measures. Yes, we have some, but not extensively. No, but we want to implement some. No plans to implement anything, or not sure. So we're now looking at what are the procedures or training or other preventative measures to protect against compliance breaches by AI that you might have implemented. Yes, we have a range of preventative measures. Yes, we have some, but not extensively. No, but we want to implement some. No plans to implement anything, or not sure. So we'll give everyone just a moment to answer that poll question, and we'll have a look at what the audience thinks around preventing the risk of a breach by AI. So an interesting spread of results there. 9% have a range of preventative measures. 28% have some, but not extensively. 24% don't have any, but want to implement some. And 10% no plans to implement anything. 28% not sure. Really interesting spread of results there. And if you want to have some more information and guidance on keeping compliant with AI and what kinds of preventative measures you should be thinking about, you can download our guide to AI compliance at work. The link is coming up now in the chat. Okay, Naomi, with so much to think about in terms of AI and data, smart data, what does the new data use and access bill supposed to do around smart data?
So we've been hearing there's a lot of talk about these smart data schemes, and they allow businesses to exchange data in a controlled and regulated manner. And the government's hope is that these schemes could drive innovation and improve competition. We saw this with the UK's open banking initiative, but at the moment, open banking is the only example of a smart data scheme in the UK. The core idea is to establish open standards and interoperability across industries, and this will enable businesses to collaborate more effectively and offer seamless experiences to customers. This could lead to better service customization, more accurate forecasting of demand, and increased efficiency in switching providers or managing accounts. At least that's the hope.
And we saw with the switch to open banking, it can be much easier to switch bank accounts, for instance. What else could it be used for?
So that's a great question. And there's a range of sectors that it could be used for, like, let's say, energy, telecommunications. We could see a lot more opportunities for consumers to switch to different competitors. Businesses could create unified customer profiles that work across multiple providers, offering a more streamlined and personalized experience. It's also something for businesses to really think about. Like, if smart data is rolled out to your sector, what could that mean for your organization and also for your customer base?
Yeah. Thank you for that. And we've covered an awful lot about what we can expect from the Data Use and Access Bill. But another issue causing a range of compliance headaches is the new Trump administration in Washington. And Harry, one area the administration has set its sights on is data privacy and possibly even undermining the EU-US data transfer agreement. What is going on here?
So the EU-US data transfer system is actually a legal framework designed to regulate the movement of personal data from the EU to the US while ensuring that EU citizens' data receives protection equivalent to that of EU law. Now, since 1995, the EU has restricted the data transfers to countries that do not provide, quote, essentially equivalent, unquote, privacy safeguards. The US, however, has a very different legal approach, which allows extensive government access to data stored by major tech companies like Amazon, Meta, and Google. This fundamental difference has led to legal conflicts, including the annulment of two previous data transfer agreements by the European Court of Justice in the Schrems and Schrems II cases. To address these concerns, the European Commission introduced the Transatlantic Data Privacy Framework, or TADPF, in 2023, aiming to restore legal grounds for transatlantic data transfers. The agreement relied heavily on the American Privacy and Civil Liberties Oversight Board to monitor compliance with US surveillance restrictions.
Naomi, I know you've been keeping a close eye on what President Trump has been up to over there. What has he gone and done now to cause this being a bit of an issue?
Oh, yeah, I'm always keeping up on what President Trump is doing now. And it's been a lot. So at the end of January 2025, President Trump dismissed 3 Democratic members of this privacy board, the PCLOB. This has raised serious concerns about the future of the TADPF. And as Harry mentioned, the PCLOB was a key oversight body ensuring that U.S. surveillance practices aligned with EU data protection standards. Its sudden reshaping has led to concerns that U.S. commitments to privacy protections could be weakened or even dismantled altogether. Privacy advocates are warning that this move could put the entire EU-US data transfer framework in jeopardy. If European regulators decide that the US no longer offers adequate protections, they may just suspend the agreement, forcing thousands of companies to find alternative ways to handle transatlantic data flows.
And Harry, what kind of disruption could we see if that actually happens? I mean, I guess it could be troubling for any EU data stored on US-based servers.
Yeah, absolutely. So there are some serious privacy concerns here. So under GDPR, any data transferred outside the EU must be protected with standards equivalent to those in the EU. However, US surveillance laws grant government agencies the ability to access data stored by US-based companies, even if that data is physically located in the EU. This puts businesses using cloud services like AWS in a really difficult position. If EU regulators determine that US companies cannot guarantee data protection, businesses could face fines or restrictions under GDPR.
So does that mean then these kind of tools we use all the time, like Zoom and Teams and Google Meet, they could then maybe be at risk of being banned in the EU?
So potentially, yes, if things get to that point. One major area of concern is that these video conferencing services are owned by US companies, which means that the US authorities could access call data, messages, and recordings without notifying users. This has huge implications for industries that handle sensitive data such as healthcare, finance, and legal services. Some US companies are trying to address these concerns by offering EU data residency options and enhanced encryption, but as long as they're subject to US laws. There's no guarantee that they can fully comply with EU privacy standards.
And Naomi, how likely do we think it is that we'll see some kind of data war erupting between the US and the EU?
So I'd actually say it's more likely than not. Just a couple of days ago, Trump issued a very strongly worded executive order to review the impact of GDPR on US companies. He said American companies and investors were sick of overseas extortion and unfair penalties. US tech companies have said themselves they are sick of the high GDPR fines the EU has been imposing. Just before the inauguration in January, Mark Zuckerberg urged President Trump to intervene in the EU's practice of fining US tech companies. He claimed that over the past 2 decades, US tech companies like Meta, but also Amazon, Apple, and have paid over $30 billion in penalties imposed by the EU. Meta alone was fined €797 million EU antitrust rules. I see. Is it hard to hear me?
Yeah, we can still hear you.
Okay, great. I'm sorry. I apologize if it's hard to hear. So, and these were related to unfair trading conditions for ad service providers, and also in addition to the many GDPR penalties that we've seen. In return, Zuckerberg in particular has made some quick and very rapid moves to more closely align himself and Meta to Trump's agenda. He announced the end of Meta's third-party faction program in favor of a community notes model, interpreted as an effort to align with the Trump administration's views on moderation and censorship. Zuckerberg also terminated Meta's diversity, equity, and inclusion programs.
And do you think then that we might see legal challenge from the EU side as well?
Yeah, absolutely. The European Court of Justice has already struck down 2 previous EU-US data transfer agreements. Privacy advocates are likely to challenge the TA board. If the agreement is invalidated, businesses will have to find alternative ways to legally transfer data, such as using SCCs or standard contractual clauses, or localizing their data storage within the EU.
And hopefully this will be resolved then, I think, without the need for more disruption. I mean, I don't think I'd be that bothered if Teams was banned, but I'm not sure what we would do without Zoom. And when our data goes all around the world, and all these risks of the data that we send to third parties, and also the third parties that we use, like Zoom and these other programs, then the risk of a data breach just grows exponentially. And we'd like to ask another poll question, the last one for the day, about that risk around third parties and data protection. So the poll about to pop up on the screen there. Do you require that all your third parties or suppliers adhere to your data protection policies? So yes, everyone must adhere to our policies. If some suppliers adhere to our policies, we would like to, but we don't have the capability. There's no way to know or not sure. So thinking about the third parties that you're working with, the suppliers in your supply chain, do they adhere to your data protection policies? Yes, everyone must adhere to our policies. Some suppliers adhere to our policies. We would like to, but we don't have the capability. No way to know or not sure. So we're going to give everyone just a moment to answer that poll question. We'll have a little look at what the audience does around supply chains. Interesting results there. 43% say yes, everyone must adhere to our policies. 15% have some suppliers adhering to policies. Another 15% would like to, but don't have the capability. 10% there's no way to know. 17% not sure. Interesting set of results there. It's such a critical risk factor, the supply chain, and it also has a significant GDPR and data protection risk, because without ensuring that the data, where you send your data on, adheres to your own policies, these companies who manage the data on your behalf can end up, in the middle of a breach, and that still impacts you as a company because you retain ownership of and responsibility for that data. So if you do want to know a little bit more about managing the data risks of your supply chain, we do have a guide to supply chain due diligence coming up in the chat now. You can take a copy of that and access our latest guide to that. The link is coming up it will be coming up in the chat in a moment. And with so many risks from data flows in the supply chain, let's talk a little bit about what businesses can do next, just in the last 10 minutes we have. Harry, what actions should we start to take now to think about compliance with DUAB?
So I think the first step for businesses is to review their current data protection policies and procedures and to identify areas where DUAB introduces new obligations or in fact opportunities as well. One of the major changes is the expanded use of legitimate interest as a legal basis for processing data. So under DUAB, some processing activities, such as direct marketing and intra-group data transfers, can now rely on recognized legitimate interests, reducing reliance on consent. However, businesses should be careful. While DUAB gives more flexibility, companies still need to conduct a balancing test to ensure that data processing under legitimate interest does not override individuals' rights. So organizations should update their data protection impact assessments, DPIAs, and ensure they document how they justify the use of legitimate interests.
And AI and automation is obviously another big area of possible opportunity, also comes with some risks. How do we bring those two things together?
So I think it's a really good idea to review how automated decision-making is used in business operations. DUAB makes it easier for businesses to use AI-driven decision-making, except when processing special category data. If businesses rely on AI for things like employment screening, credit decisions, or customer profiling, they need to ensure they have safeguards in place, such as human oversight and appeal mechanisms for affected individuals. Because although this needs to be clearer, and it's supposed to be easier, the ICO have pushed back against companies who routinely use biometric data for those kind of employment purposes. Secro, one of the UK's largest employers, was told to stop using fingerprint scanners and facial recognition software for staff clocking on and off, in a warning that could force many other employers to change their practices. The ICO has also warned that Google's recent decision to allow advertisers to track customers' digital fingerprints was irresponsible and threatened to intervene.
Very, very good to know and to watch out for and to think about, especially maybe before we go and buy some expensive biometric system. Maybe it's worth having a wee think about, is it going to be compliant with future legislation? Naomi, what should we be thinking about looking at and updating and reviewing within our own organizations once DUAB comes into force?
Yeah, that's a great question. So first of all, companies should update their privacy policies to reflect the new data processing grounds introduced by DUAB, including recognized legitimate interests. They should also revise their procedures for handling subject access requests, those SA. DUAB allows organizations to limit the scope of searches to what is reasonable and proportionate, and introduces a stop the clock mechanism, Harry referred to that before, if clarification is needed from the data subject. Businesses should update internal SAR handling procedures to ensure compliance with all these new provisions. So one of the most significant changes is the relaxation of marketing consent rules. DUAB allows third parties to conduct direct marketing on an opt-out basis rather than requiring explicit consent. This is a really complex area, though, so it's important to spend time on it to get it right before making significant changes. Businesses that rely on email, SMS, or phone marketing should revisit their opt-in, opt-out policies and marketing consent forms to take advantage of these changes. However, companies should still ensure they comply with the Privacy and Electronics Communications Regulations, the PECR, as these rules remain in place alongside DUAB.
What about the issues with international data transfers, particularly when it comes to the issues with the US?
So the UK can designate their own jurisdictions as having equivalent levels of data protection. But still, the global nature of data makes it very easy for things to get complicated really quickly. With the EU-US data privacy framework under potential threat, companies may need to consider alternative data storage solutions, such as using UK or EU-based cloud providers to reduce the risk of noncompliance with GDPR. Also, if the EU reassesses UK adequacy due to DUAB's divergence from GDPR, businesses might need to adopt standard contractual clauses or binding corporate rules to continue data transfers.
Thank you very much for that. I know I've had a couple of questions in that subject as well, so I'll just answer a couple of those quite quickly. One was asking, because the UK is not in the EU anymore, do the concerns around transatlantic data sharing still apply to US companies operating in the UK? The answer would be not directly. If the EU was to cancel its data sharing with the US, then the UK would be technically unaffected, but that could mean that if the UK continues that without doing any changes or without doing any amendments to its own relationship with UK to US transfers, then the EU might decide, well, UK is not get adequacy anymore because it's taking a less advanced view of data protection. And then another question on a similar vein was, what about US companies with data centers inside the EU, such as AWS in Dublin? Will they be subject to the parent laws in the US? So the short answer is we know it. For what we know at the moment is yes, that's really the crux of the issue, is that even if a US company has data in the EU, that could potentially have an impact, because the US might use its powers to take that data or to do something with that data. So these are still live questions to understand, but potentially there is still a level or element of risk there. So obviously an awful lot for us all to think about in terms of comes to data protection. Harry, what should compliance teams be prioritizing then over the next year?
So I think the opportunity for new smart data schemes like the ones we saw with open banking will have a big impact. DUAB gives the government the power to expand it to other industries. Compliance teams in energy, telecoms, and financial services should start preparing for the potential impact. If smart data is introduced in their sector, businesses may be required to participate in regulated data sharing schemes, meaning they will need to build APIs and integrate with third-party providers, and of course, make sure those are secure and compliant with AI regulations in particular. And just on the topic of AI as well, compliance teams should ensure that AI-driven decision-making processes are documented, transparent, and certainly auditable. They should introduce internal AI governance frameworks if they don't already manage risks, especially for high impact decisions like hiring or financial approvals. If businesses use AI models trained on third-party data, then to access copyright and intellectual property risks, as DUAB is currently facing scrutiny over AI data scraping rules. There was just a case in the US where a judge ruled that an AI company called Ross Intelligence use of legal content owned by Westlaw to train an AI tool was not fair use. Ross had attempted to license content from Westlaw, but this request was denied. Then it acquired 25,000 bulk memos built using copyrighted Westlaw headnotes. The judge rejected Ross's fair use defense, stating its use was commercial, not non-transformative, and aimed at competing with Westlaw. So there's an evolving body of case law here that's really important to keep up to date with.
Absolutely. And just on the last point, what about the challenges of this new information commission to replace the ICO? What should we be thinking about with that?
So the new information commission will have greater powers to demand reports and conduct investigations, meaning businesses need to ensure robust record keeping and compliance reporting. Fines for marketing violations and cookie law breaches are increasing. So teams should review their direct marketing policies and cookie consent mechanisms to avoid penalties. There's a lot of important changes happening and a lot to keep up with. So it's really important to remember and that DUAB, which we think will be passed in the next few months, is really only the starting point of what to worry about when it comes to data protection compliance.
Great. Well, thank you so much. A great point to end on. That is all we have time for today. We really appreciate you being with us. Thank you so much to our panelists, Naomi Grossman, and also to Harry Lindsay. Thank you to everyone who came along today to ask your questions. There's a list of the upcoming webinars that we have with some links coming up again in the chat. We're going to leave the webinar room open for a little bit longer. So if you want to ask us any more questions, if you'd like to ask for a demo of either our courses or our OmniTrack tracking solution, you can feel free to do that now. I know there was a number of questions we weren't able to get to within the hour, but we are going to try and get back to you by email with a more detailed answer. A recording of the webinar will be sent to everyone a bit later on, so you will get access to that. And if you like any more information about how VinciWorks can help, do let us know in the chat box. We'll be more than happy to help. Thank you again for coming along, and we look forward to seeing you next time. Bye for now.